public office holders and members is available on our website's public registry.
Both the Act and the Code, we focus on private interests that might affect financial or business decisions for personal gain. Essentially, the main purpose of our work are first to help elected and appointed officials recognize and manage conflicts of interest, and second, to facilitate the movement of qualified people in and out of the public service without issue. Regarding the current issue of ArriveCAN, I understand there are ongoing investigations by other organizations. To our knowledge, no person subject to the Act or the Code were involved in this matter. Hence, we have no jurisdiction, and I have no comments to make on that.
I'm happy to answer your questions.
Et voilà, merci beaucoup.
Thank you very much.
Januous, you have the floor for 6 minutes, please.
So thank you, Chair. I want to thank the Commissioner for being here, and I look forward to asking him some questions very shortly. As members know, we do have some unfinished business on the ArriveCAN issue from yesterday that I'd like to propose we quickly wrap up.
Yeah, he's going to get to his motion.
I've sent a revised motion to the Chair, which builds on our work yesterday, but which incorporates feedback from other parties, which I hope will be able to facilitate us moving forward quickly. So if the clerk can distribute that motion now, and I will read it as I move it.
Mr. Jennings, just 1 second. We will send it. You sent that to the clerk, not to the chair, and I appreciate that. I just wanted to correct that just for the record.
Yes. Yeah.
And the clerk, now that you're speaking to it, will send that out.
And Mr. Clerk, it was labeled V3 in the email because I know I had some further thoughts after I initially. So all right, just 1 second, Mr.
General. I just want to. So, Mr. Von Finkenstein, we're going to debate a motion here for a few minutes. If you could just stand down for it, we'll get back to you. I hope very, very soon. We had a discussion on this yesterday. There is some agreement, but not universal agreement, so we might have a debate around this, and then I'll try to wrap it up as quickly as possible and come back to you. If in the meantime, if you do want to stand up, walk around, that's fine. You're not required to remain in your seats by any means. It's at your discretion, but we'll come back to you, and I'll give you plenty of notice on that. Mr. Jennings, you have the floor, please.
Thank you, and I spoke to the motion yesterday, but I'll just read it out and articulate some of the differences with the new motion. The new motion says, in light of testimony and evidence provided by Diane Daly, the committee ordered the production from the government of the recording, which Ms. Daly referenced in her testimony, of her 3.5-hour interview with CBSA, and called the following people to appear before the committee on ArriveCAN, and particularly to respond to the new information Ms. Daly has presented. Lisanne Bolduc, Tom von Schoenberg, Ariane Reza, Aaron Gorman, and additional officials and experts with knowledge of TBIPs. Further, that the committee write to Christian Firth and ask him to provide information and evidence supporting his claims at the bar of the House regarding Diane Daly, including the time, location, and names of other participants at the alleged meetings with her, and that he respond to the committee's request for information by Labor Day. So the changes that were made, I think one Liberal member had earlier raised concern about not being clear what recording was being referred to. I thought it was clear from the testimony, but I just added a little bit more information to clarify what recording we're seeking. Mr. Desjardins made the very good suggestion about having officials that can speak to TBIPs, and I think that's a good suggestion, so I've added that in. Ms. Sinclair Gagné had suggested that we not invite Christian Firth, and what I proposed instead is that we simply ask Mr. Firth to send us follow-up information evidence. So we would not be calling Mr. Firth. We would just be sending a request to him to respond in writing to the committee, responding to
which he won't. He'll just
deny testimony, his comments on April 17th, and inviting him to provide some additional evidence to support his version of events. So I think rather than having a flurry of amendments, I mean, people are welcome to propose amendments, of course, but I thought I would try to speed up the process a little bit by incorporating the feedback we received from various parties. and the principle of following up on Ms. Daly's really groundbreaking testimony yesterday to be able to more effectively assess her claims and put questions to others about that testimony, I think is clearly important. I got the sense that there was majority support for the principles of my motion, and hopefully with these modifications, we'll be able to get it done quickly and get back to speaking with the ethics commissioner.
Thank you, Mr. Generous. I have a speaking list already. Mr. Daly. Yes, Michelle?
Yeah, just a point of order.
Yes.
We're dealing with an entirely new motion, so can we suspend so we can look at this?
Sure,
It's
I will.
not
I'll speak to that.
entirely
Yes.
new
So
motion.
I think we all heard Mr. Generous kind of speak to his proposed new wording. And 5 minutes, 10 minutes. What are you thinking?
Well, 10 is good.
Tell you what. Let's start with 5, and if you nod, we'll make it 5 to 10 minutes. But I'll look to you if we seem to be coming to some agreement resolution. We'll come back. If there's obviously a deadlock, we'll have to deal with that as well. So I'll suspend for 5 to 10 minutes.
Okay, so if you just got in here, basically what's happening is the Conservatives are trying to pass a motion in order to get more top officials from the CBSA and Aaron O'Gorman, who's already testified, and they want writings from Christian Firth because after Diane Daly's testimony yesterday, we're very confused as to what he said in the House of Commons when he was called to the bar. So we just want to make sure that we're getting these guys coming in as soon as the House resits again, which is in September. So that's what they're trying to do. We're all trying to make sure that basically we get more evidence to support what's going on here with the ArriveCAN scandal. Sorry. So right after this, we should get, as long as they don't take too long with this. I don't know why Ms. Shanahan needs to review the motion. Garnett talked about this motion for like 20 minutes yesterday, and all he's added is a little bit of, like, he's added like 10 words to make it more clear as to what exactly the recording is and stuff like that. It's not really changed the motion at all. I think she just wants to read it and make sure that there's no other changes. I'm not really sure, but it shouldn't take too long, and then hopefully we get right to the ethics commissioner. And I think Conservatives are going to start first, if I'm not mistaken. The speaking order should be Barrett or Brock first. So 5-10 minutes. You know what? While they're doing that, I wanted to show Aaron O'Gorman's last testimony from when Brock was grilling her. Because if you don't know Aaron O'Gorman, she's one of the top officials, or was one of the top officials at the CBSA during the ArriveCAN scandal. And this is what she had to say about it. So we'll quickly swap to this for a sec.
Thank you all for ratifying with a slight amendment the work plan that had been sent to you all. Going back to our witnesses, Mr. Brock, you have the floor.
He didn't like that.
Thank you, Chair. Ms. O'Gorman, you appeared at OGO, this OGO committee, on October 24th, 2023. You informed this committee before your appearance at that meeting. You visited the PCO at 80 Wellington at 2 p.m. You then attended the OGO committee at 3:30 p.m. and the next morning visited 80 Wellington again, the PCO's office. This is all pursuant to your calendar. Did you meet with PMO officials?
No.
Such a liar. What?
Did you meet with PCO officials?
I don't know the specific meeting that you're talking about, but if I was at PCO, I would have
Ma'am,
been...
I just repeated the meetings that you attended. October 24th, 1 hour before your committee appearance, and the following your committee appearance on the 25th. So I'll ask again, did you meet with PMO officials on both of those dates?
I would have to review my calendar. I don't recall
What do you
meeting
mean?
in person with PMO officials
You don't know what you did?
for any meetings, but this is more than 6 months ago. So I guess if Mr. Chair, if there's a specific question that the member wants to know, pointing out dates of meetings 6 months ago,
Ma'am,
I'm hard
this
pressed
is
to.
important. This is an important question, and we want an answer to it.
Like
Who at the PMO and the PCO office did you meet with before and after your appearance at the OGO committee?
I would have to review my calendar. I don't have it in front of me.
he just
And
told you
you'll
what your
provide this
calendar
committee
was.
with all of those names in the PMO office that you met with and the PCO office you met with.
So, Mr. Chair,
with
the
Trudeau.
member is
Did you talk?
stating as a fact that I met with
Yeah,
PMO. I
just-
have not agreed to any facts, so please let that be clear.
I stopped the clock, Mr. Brock. So just there's a request for information. I believe Ms. O'Gorman said she would check her schedule. I just wanted to clarify that. I just wanted to double check. I don't want to put words in your mouth. So
The member has my schedule.
Sorry, I didn't
So
realize
if,
how loud
if
it
the people aren't listed, I can see if I can go in and find that, but I will take that back.
thank you very much. Mr. Brock, you have 2
Mr.
minutes,
Go-
50 seconds. Back to you.
Ms. O'Gorman, did you talk about the ArriveCAN issue?
As I said, I don't recall those meetings. I don't have the information in front of me. I have spoken
It's
to
funny-
PCO.
I'll stop you right there. Ms. O'Gorman, it is really funny that now, some several months removed, you have great difficulty remembering your attendance at the PCO and PMO's office. Yet when the question was put to you by myself at an earlier appearance, you remembered exactly attending, and you told us at that time that it was a mere coincidence that you were attending before your committee appearance. And I'm now telling you that this is what you had said previously. So it's very coincidental, ma'am, that you can't remember now. So clearly this was about your appearance at committee, and it was clearly about the ArriveCAN study. Do you dispute that?
I do. I absolutely.
Okay, they are back. Let's get to that.
Usually, if you're ready, you are first on my speaking list. Over to you, please. And then I had Ms. Khalid after that, and then Nathalie Sinclair-Desgagne. So, Mr. Daly, you have the floor.
Thank you very much, Mr. Chair, and I am happy to see that there's been amendments to the motion to include an amendment that I had sent to the clerk in relation to strengthening the original motion to include the members of the officials of the TBIPS program. As members of our committee know, Ms. Daly did provide good testimony and recommendations as to the source of some of these issues, and the TBIPS in particular is something we haven't necessarily looked at in terms of how qualifying consultants like GC Strategies could have ended up on a list that would have preferred them to certain contracts. And I think that's a pretty serious issue that requires investigation. And it's the reason why I'm glad to see that we were able to include that. So I just want to thank Mr. Genuis for including that, and I would happily withdraw my amendment that was submitted to the clerk. As I see it, that requirement's been satisfied here. Thank you very much.
Thank you. Ms. Khalid, would you like the floor? No? Okay. Madame Sinclair-Desgagne. Vous avez la parole, s'il vous plaît.
You have the floor. I will make this very quick. I'd like to thank Mr. Genuis for having made the modifications that we suggested yesterday, including the one from Mr. Desjardins, which I think was very important because the main issue, it's not a witch hunt. It's about improving to the extent possible within the federal government, pending Quebec's not being a part of this federal state anymore, but it's about improving the TBIPS system that it seems to be causing a lot of problem in the procurement system. And a letter to Mr. Firth, I believe, will have a higher chance of getting an answer when it comes to the testimony of Ms. Daly, which contradicted his testimony. So we're going to support this motion.
Et merci beaucoup.
And thank you very much.
Clerk, could you call a roll call, please? Oh, Ms. Chen, I thought you, okay, no, I'll go ahead, Ms. Shanahan. Just 1 second, clerk. Please, Ms. Shanahan, go ahead.
All right. Well, thank you very much, Chair. And yeah, we appreciate that we had a chance to look over the revisions that were done to the motion. But the essential problem with the motion is still there, which is that listening to a recording that was recorded unknowingly to other third parties, and as part of a private investigation being duly undertaken by the proper authorities, risk to potentially sabotage that investigation, to compromise that investigation. And I know that we have experienced members on this committee who are very, very much aware of this. So I do wonder what the, again, as public accounts, where we pride ourselves on being objective, on being, sort of doing that oversight, making sure that other people are doing their jobs. I do question why we are going after this, which I believe is a 3.5-hour recording, if I'm correct.
How do you know how long the recording is?
And I'm also wondering, Chair, just how that recording will be shared with the committee, if it will be that we sit and listen to it for 3.5 hours, or that it's a transcript, or however it is. But I just wanted on the record that unfortunately, once again, we have members of Parliament seeking to duplicate and possibly compromise work that is being done by other duly authorized investigators.
She doesn't want to listen to the recording because it damns the Liberals.
Thank you very much. Clerk, could you please call the vote on this?
Come on, let's get this vote passed.
Ms. Bradford.
Come on.
Affirmative.
Yes.
Ms. Khalid.
Yes.
Okay, the Liberals are voting yes.
Ms. Shanahan.
Regretfully, yes.
Okay.
Mr. Ali.
You see how John just smiled there?
Ms. Yip.
Yes.
Mr. Brock.
Yes.
Brock's in the house.
Mr. Barrett.
Yes.
Barronator's in the house.
Mr. Jennis.
Yes.
Madame Sinclair Desgagnés.
Oui.
Mr. Desjardins.
I vote in favor.
All right.
8 yeas,
Unanimous pass.
nays opt.
Thank you all very much.
Sweet.
I'm going to now return to our witnesses, who both appear to be ready. I thank them both for their patience. The time on the clock is, I believe it's going to Mr. Barrett. Mr. Genuis, is it back to you, or is it over to your colleague? Yes,
to me.
Pardon me. Back to Mr. Genuis. Ms. Khalid, is this a point
Mr.
of order?
Chair,
Yes.
just a point of clarification. My understanding is, according to the standing orders, that once somebody moves a motion, that it passes to the next speaker in line. I just wanted to confirm that. I'm not 100% sure.
I'll check on that. That's not been the practice of the committee, but if I have been, if I'm incorrect, I will get back. I'll check with the clerk on that one. Thank you. I'm informed it is not in the standing orders. It is at the chair's discretion, and my practice has been to, for all members from all parties, to suspend the clock when we move into a debate, and then
even though that
return
passed,
to that once the debate is concluded.
The problem is
so,
the Liberals can still
Ms.
filibuster
Genuis,
in the
you
meeting.
do have 5 minutes and 30 seconds now.
If they decide
the floor
to.
is yours.
Well, thank you, Chair. Just to say, first of all, I'm very glad to see that motion passed. I will say Ms. Shanahan's comments are totally incorrect, and I think they ignore Ms. Daly's testimony. She made very serious allegations about intimidation of her as part of an internal government process, a process that clearly is compromised and subject to criticism. So for after hearing those 2 hours of testimony, Ms. Shanahan to say, we should just trust the internal process, doesn't make much sense to me. We're parliamentarians. Our job is to hold government accountable, and that's what the passage of this motion, which clearly had the support of the opposition and in the end passed unanimously, that's what it allows us to do, is get to the bottom of what happened. So to the Ethics Commissioner, thank you very much again for being here. Clearly there are major ethical issues involved in the ArriveCAN scandal. You've talked about your jurisdiction, that is applying to certain people and others. I just want to dig into that. So some of the facts we have heard at this committee, as well as the Government Operations Committee, are serious allegations about Min Doan deleting emails, as well as a conflict of interest issue involving Mr. David Yao, who was a contractor while he was working for the government, who's essentially double dipping. And we've dug further into that. We've looked for further information about this practice of people double dipping as government employees and as contractors. We put forward a motion calling for the end of this double dipping, and it passed with the support of all opposition parties, although Liberals opposed that. Could you help us understand whether or not these issues involving David Yao, the double dipping questions, as well as the deletion of emails, allegations involving Min Doan, whether or not those would fall under your jurisdiction to deal with, and why or why not?
Thank you. No, they do not fall under my jurisdiction. Basically, my jurisdiction is to deal with issues of conflict of interest. Conflict of interest by elected officials like yourself, or by people who are what the Act calls reporting public office holders, which are basically people who are appointed by governor and council and have a senior position. And in this case, all the people you mentioned, none of them falls under either category. So there are obviously other institutions who deal with this. Primarily the Commissioner of Public Service Integrity deals with it. There are provisions under the Public Service Employment Act, etc. These are all activities which we like double dipping, etc., which clearly are not ethical and shouldn't be pursued, but they are not part of my mandate.
Okay, thank you. So on the double dipping front, you said clearly not ethical, but only triggers your involvement depending on what level. So if we had a case where a member of parliament or a very senior public servant was involved in this double dipping, they owned a company that was bidding on government contracts at their own department even perhaps, while they were also holding this position, that would trigger your involvement. But it's not a question of the activity itself. It's a question of the level of the person that is doing that activity. Is that correct?
I can only deal with issues that involves senior public servants appointed by order and council or elected members of the House of Commons. Okay,
thank you. So I guess a way of getting at this issue would be to ask a hypothetical then, which is that if you had a senior public servant or a member of parliament who owned a company that was bidding on government contracts, presumably you would have concerns about that, right? Or would you? I don't know. Put words in your mouth. How would you respond to that?
Excuse me. First of all, that senior public servant in your hypothetical would have to disclose all of this in his report when he's appointed, or if which happens during his tenure while he acquires it. We would deal with them. Does this create a conflict or not, and what are the remedies that is it? Do you have to get rid of the company? Do you have to put it in a public trust, in a blind trust, or whatever? And secondly, a member of the House of Commons can ask me to investigate. In either case, I would look at it, and then if I find out there are grounds for launching, reasonable grounds for there being a breach of the Act, then I will launch an investigation. If I come across something that is criminal or potentially criminal, I have to refer it over to the RCMP and seize my activities. So that the criminal aspect, if there is any, can be resolved.
Okay, so just in the last 10 seconds I have, sir, it does seem that comparing your description of what would be appropriate to what happened with, for instance, David Yao, it's clear that based on your expertise, there are serious ethical problems because there was a lack of disclosure in the case of David Yao. Again, it's not within your jurisdiction to investigate him specifically, but I think the information you're providing about what would be considered ethical or not in the case of people you would investigate is very helpful in the area of double dipping. So thank you for that testimony.
Excuse me just for 1 second. Mr. Von Finkenstein, could you just either move your microphone forward or just stand back a little bit? Your proximity is just creating a little bit of feedback, which is difficult for the interpreters. So maybe say a few words. We can just double check it.
Is this better? Can you hear me now clearly, interpreter?
I'll look to the interpreters. Is that a little better for the... Back a little bit more? Maybe back a little bit more, or push the microphone further away from you, or even push the box away from you. So,
is this better? Can you hear me now clearly?
That? I'm getting thumbs up. Thank you very much, Commissioner. Mr. Jennings, pardon me, Mr. Von Finkenstein.
I think I had 10 minutes left, right?
No, you yeah. Mr. Von Finkenstein, do you have any comments for Mr. Genuis?
No,
I felt there was more of a
question, I believe.
I didn't think there was a question there as well. Okay, I just want to double check with you. Ms. Yip, you have the floor for 6 minutes, please.
Thank you, Chair, and I'd like to thank the witnesses for coming today and for your patience while we dealt with the motion. For Canadians at home, Commissioner, what is the role of an ethics commissioner?
As I mentioned, although the title is Conflict of Interest and Ethics, it really is primarily to deal with conflicts of interest. And obviously, when you do that, you look at you have ethical consideration. But the main thing is to make the Act quite clearly provide that people who have an elected position in the House of Commons, or people under the Code or under the Act, if you are an appointed official to a senior public service commission, you have to behave ethically. You can't further your own interests, the interest of your friends or family, etc., or use your job in a way to favor somebody, etc. And that's what I concentrate on. But the way this system works is that, in effect, at the beginning of your appointment, you make a report. We look at it and say, there's a problem here, there's a problem there, etc., and suggest ways that can be remedied. Then throughout the tenure, the person annually makes an update of that report. And our job is to, as I mentioned many times before, to ensure that the best talent can come into the public service and out. If you're good, if you're talented, you will have conflicts. There's no doubt about it. The question is how to manage it, and my job is there to manage it and try to avoid conflicts. And then in the instances where there is behavior that seems to be suspicious and gives reasonable grounds to investigation, I can do it either on my own initiative or if requested by a member of the Parliament.
Is your office part of the House of Commons or the government?
Yes, I am. I report to the Speaker of the House, and my office is part of the House of Commons and subject to the rules of the House of Commons.
Are you an independent officer of the House of Commons?
Yes.
Perhaps you could elaborate on that?
Well,
she doesn't know what he does.
If you look at the Act, excuse me, and the Code, basically it gives a huge amount of discretion to the Commissioner to decide what is a conflict, what behavior that can be permitted, or what are the remedies that should be applied. If the person to whom I give these directions refuses to do it, or it thinks they have an issue with it and I am wrong, they can go to the federal court and ask for judicial review of the decision. Other than that, nobody looks and has an ability to tell me how to decide or criticize or ask me to take back a decision or anything. I'm completely independent, but I report publicly everything I do to the Speaker of the House of Commons, and of course I publish an annual report.
Thanks for making that clear. Have you opened an investigation into the ArriveCAN procurement?
I have not, because for what I just told your colleague, I have no jurisdiction. My jurisdiction is over people who are appointed by order in council and are what the Act calls a reporting public office holder. None of the people involved so far that have been mentioned, either in the AG's report or in the public proceedings before you, qualify as reporting public office holders. So I have no jurisdiction to look into it.
How does the director of the CBSA not fall under that purview?
So you do not have any reason to believe that any member of parliament, minister, or their staff have violated the Conflict of Interest Act or code through this procurement?
Indeed, that's exactly it, and nobody has furnished any evidence or pointed up anything that would seem to involve what we, as the Act calls, a reporting public office holder.
No, let's get to Brock. Let's get to MP Brock.
Do you believe that
this chick knows
any
nothing.
member of the Liberal government has personally benefited from the selection of any ArriveCAN contractors?
It's not a question of what I believe or not believe. I deal with evidence. I have to look at a situation and find, on the basis of evidence, whether there has been a violation of the Act or not. As I say, so far I don't have any jurisdiction. If I had jurisdiction, then I would have to look at the facts presented and decide whether there are reasonable grounds to make an investigation, and if so, I would do an investigation. But that's very far away from where we are right now.
So just to be clear, there's no investigation into this because you don't believe anyone has violated the Act or the code?
There's no investigation because I don't have jurisdiction. My jurisdiction depends on people who are reporting public office holders. There's no evidence, no referral to any public office holder who has been involved in this. Hence, I cannot investigate. I have no jurisdiction to do anything. If and when such evidence emerges, then I have to decide whether it warrants an investigation or not.
So is that your threshold that needs to be met for your office to open an investigation?
Well, first of all, I have to have jurisdiction, number one. And then the Act says there have to be reasonable grounds for me to believe that an investigation is required.
Et voilà. Merci beaucoup. Thank you very much. Suivant, c'est Madame.
Up next is Ms. Sinclair de Gagné for 6 minutes, please.
Oh, come on. Let's get to Brock already.
Hello, Commissioner. Thank you for being with us today. Well, I will start my line of questioning by reminding the importance of your role, because a lack of ethical adherence is not the equivalent of something being illegal. And when you look at conflicts of interest and ethical situations of ethics, it's interesting because it's not necessarily illegal, but clearly in some cases there are ethical problems in the behavior of some, for instance. So my first question to you will be the following. The most common...
Oh. What just happened? Oh, there we go.
Just a second, Ms. Sinclair de Gagné, because we lost you. Your screen froze for a couple seconds. So if you could just restart your question, please. Of course. When it comes to conflicts of interest, we often think about financial conflicts of interest. So, for instance, someone has an interest, they own a company, and they're at the same time an elected official or appointed by the government, and in that case, there might be a conflict of interest. But I'd like to hear your opinion on the following. Should the conflict of interest be absolutely financial in nature? If there is a position that is sought after, or there's a high-ranking official that is appointed by the government, and this person being nominated to this position might also trigger other conflicts of interest of the type that are not necessarily financial. Is that the case? Of course, there might be conflicts of interest that are not financial in nature. But when you look at the definition of conflict of interest for the application of this act, a an appointed official or an elected official is considered to be in a conflict of interest when they are considered to be driving personal benefit by having access to their position that would otherwise not be available to other people. So that is the crux of the matter. So is there an interest that this person in question is deriving
you just proved it.
Compared to someone else just because they are in a certain position? The definition is very strict. We're not talking about the general ethical framework. We're talking about the actions of appointed or elected officials who might be in a favorable situation compared to others. Okay. And you also said at the outset that you scrutinize elected and appointed officials. Does that include presidents of agencies and deputy ministers who are nominated by the government? Yes, they are included. So, hypothetically speaking, there could be conflicts of interest in a situation where the person occupying a position, a deputy minister, let's say, if they ask that something like ArriveCAN is to be shelved or to be forgotten, if the ArriveCAN situation is not resolved and this person stays in their position, would that be a type of conflict of interest? It depends on the facts. What would be the purpose of the actions of this deputy minister and how do they benefit from these actions? So we would need to be asking these questions. Is it because there is pressure and potential retaliation? But that's, again, not part of my jurisdiction. That would go to another commissioner. But if you can establish a connection with the actions of this individual and a personal benefit or outcome that benefits the deputy minister, at that point in time, yes, I could be involved. Because yesterday we had testimony that was quite troubling in the sense that, and I'm not saying the witness was right in that position, but a deputy minister's name was invoked, and the argument was that this person would have a certain benefit in the ArriveCAN situation, and that they would be in favor of making sure that people forget about this situation.
How can he not investigate that?
So
what does he
would
do
that
all
be
day?
a conflict of interest in terms of their professional integrity? Who is in charge of ethics issues or conflicts of interest issues when it comes to public servants who are not appointed? I think it will be the Commissioner of Public Integrity. And it also depends on the facts. Maybe the public service also has a similar function. But that wouldn't be part of our mandate or jurisdiction. Mr. Chair, how much time do I have left? None. And that's it. You had 0 seconds left. And up next, we have Mr. Desjardins.
Or for 6 minutes.
Oh, for God's sakes. Can we just get to Brock already?
Thank you very much, Mr. Chair, and I want to thank the Commissioner and the Legal Counsel representative for being with us today. I know many of the questions that were posed in relation to ArriveCAN you've already answered, largely comments about it being out of your jurisdiction. Is that fair summation?
Yeah. Yes, and what happens there is, I know in no way condone it or think it's minimal or anything like that. It's just not part of my jurisdiction.
No, I understand that. And so for those purposes, I want to turn to a particular ethical issue that is placating Canada at the moment, which I think was also highlighted in the ArriveCAN issue, which is Indigenous procurement. Adjacent to Indigenous procurement, there are serious issues of pretendianism, quote unquote. This issue of officials and even members of parliament and other elected officials across the country claiming to be Indigenous for the purposes of trying to benefit in some way, shape, or form from doing that. As an Indigenous member of parliament, myself, I'm troubled by what has been a consistent and ongoing effort to use Indigenous identity as a tool, which is deeply troubling for Indigenous nations across the country, including my own and many others that we work with. And so it's really troubling to know that this is happening. It seems to me as though this could fall within your mandate in the future, a way or a tool for us to combat pretendianism, because it is being used by public officials and it is being used by members of parliament at times in order to deflect or to even protect themselves from claims of very legitimate racism. And so it's a concern to me, and I think a concern to the public. We've seen this in the last few years, for example, very high-ranking or high-profile persons in Canada and across the United States we had to get giant news agencies to investigate whether or not they were truly Indigenous, and they found out that they weren't after decades of benefiting from identity fraud. In Canada, there was even a severe case of 2 students attempting to identify themselves as Indigenous for the purposes of getting benefits there. And so it's a growing concern, and I hope, Commissioner, you can understand Indigenous people's very legitimate fear of identity fraud. And this is something that I think that requires more thought, more investigation, and more understanding, and also cooperation with Indigenous nations towards a way or a program or a process to verify when officials are in fact using identity as a weapon or using it as a tool of fraud in order to advance themselves. Is this something that concerns you at all, particularly within the ethics and conflict of interest laws?
Yeah, of course, it's of great concern and something that needs to be addressed and dealt with. It's unfortunately, it does not fall under my jurisdiction. You use the word fraud, identity fraud. If it truly is fraud, then it becomes a criminal offense. If it's just misrepresentation or something else, it may not amount to criminal, but it still should not be allowed and should be to my knowledge, there is no specific program that addresses it as such. It is a part of the general ethics of procurement, trying to make sure that people play by the rules or not. And if I'm not a procurement expert, I don't know to what extent the verification process needs to be tightened or needs to be improved or not.
I heard you respond to one of my colleagues about a framework of understanding that you come to in identifying could, in fact, put them into a position where they would unduly benefit. Could you please describe again what is a conflict of interest, in particular with the angle of seeing it as using Indigenous identity, even in the act of fraud, which is a criminal offense, but also in the act of conflict of interest, could be something within your purview, within the framework you understand as a conflict of interest?
You know, it all depends on the definition of the conflict of interest. And as I've pointed out to your colleague, it has to be an action in exercise of official power, duty, or function that provides an opportunity to further his or her private interest, or those of his or her relatives or friends, or improperly further another person's interest. Now, given the situation which you posit involving somebody impersonating to be Indigenous when he is not, and therefore getting the contract, it is the action of that person. It's not necessarily of the action of the person who gives them the contract. So therefore, I don't see quite how conflict of interest applies. It is clearly an action that should not be allowed, that should be prevented or prosecuted.
How is it not a conflict?
But it doesn't really fit into the whole concept of conflict
it does.
of interest.
If you're a public official,
beyond the concept of conflict of interest, your office deals with
and you own a
issues
company,
of ethics.
That's conflict
as far
of interest.
as your understanding of the process of identifying an ethical issue, which I believe this to be an ethical issue,
it is an ethical issue.
Falsely identifying as Indigenous for the political, personal, and private benefit of attempting to displace one's own racist actions, for example, or one's own perceived racist actions in order to deflect or even to benefit from what could be a very racist claim, but is negated because of a claim of it being Indigenous. This is something that exists in the personal world and the political world. And as far as your standards of ethics and understanding of ethics, does that breach or broach any kind of responsibility or effort that your office can undertake to better prevent that from happening?
Let's start with the beginning of your question. You said we administer ethics. We do not. We administer conflict of interest, and in doing so, we follow ethical principles. Although the title of the office is Commissioner of Public Interest, of Conflict of Interest and Ethics, there's not a single provision that uses the word ethics or deals with ethics. It is sort of the tough subtext to all that we're doing. Why are we doing this? To make sure that people have confidence in the Canadian government and it's done ethically. But we don't have any specific activity mandated to look at the ethics, etc. There are all sorts of other government or institutions, but it really isn't part of our job.
What institution would you recommend?
I'm afraid that
do?
we've exceeded the time. I appreciate it. We'll come back to you certainly.
Okay,
Turning now to the start of the second round. Mr. Barrett, you have the floor for 5 minutes.
Commissioner, I just want to clear this up for Liberal members who unsurprisingly don't seem to know what it is that you do here. But can you please confirm that you do not have jurisdiction or mandate over the ArriveCAN scandal?
I do not have, as I mentioned in my opening remarks, my jurisdiction only extends to reporting public office holders, i.e. senior public servants who have been appointed by Order and Council, to put it in common language.
And the people that do fall under your mandate, lavish dinners, whiskey tastings, being given to those individuals by suppliers or involved parties, that would be that would fall under your mandate and trigger an investigation.
It triggers an investigation or not depends on the specific facts, but clearly the conduct of reporting public office holders with suppliers, customers, or something like this, etc., depending what the situation is, what happens, etc., would be subject to the act and could lead to an investigation.
Of course. Yeah, it seems like there was an attempt, with you having been suggested as a witness, that this would be an opportunity for the government to exonerate themselves from the wrongdoing that's occurred in this $60 million scandal. But of course, they summoned the wrong officer of Parliament to offer that exoneration if it were available. I have a question for you, Commissioner, about Ms. Annette Verscherian, who was the Liberal-appointed Chair of Sustainable Development Technologies Canada. That's the $1 billion green slush fund. Why was she subject to the Conflict of Interest Act?
Well, she was the chairman of the STDC, and as such appointed by Governor and Council, and so she was subject to the Conflict of Interest Act. She declared her conflict, and she went through the rules of when she was appointed, letting us know her interests, what's there. We appointed a counselor, as we call them, to her to make sure that her affairs would all be in such a way that there wouldn't be a conflict of interest.
Who was the head of government at the time that she was appointed?
Do you know, Michael?
She was appointed in 2019, so it would be the current government.
So the head of government was Justin Trudeau?
Yes.
What sections of the Conflict of Interest Act did Ms. Verscherian violate while chair of the board at the Prime Minister's slush fund, having been appointed by his government?
Well, you read my report. So I made an extensive investigation into her activities, and I found out, first of all, that she's not only head of the STDC, she was also head of two not-for-profit organizations, one called Verschuren Center and one Mars. And as such, which are basically incubator organizations. Right. And certain companies came forward which were sponsored by these incubators. She declared her conflict of interest, but then there was an actual vote, what they called, what is called.
I apologize for the interruption, sir. I'm quite tight for time. I was looking for the number at which sections that she violated. Are you able to reference those offhand, or just to enumerate the number of sections that she was found to have violated?
Yes. Michael, give him the details, please.
So there were two provisions. It was subsection 6.1 of the Act and section 21.
Sir, are you able to tell us how many hundreds of thousands of dollars
your mic
have been the beneficiary of as a result of the conflict?
As part of the report, we didn't do the calculation based on the votes and the dollar amounts associated with those votes.
So we have the Prime Minister's hand-picked chair of his billion-dollar green slush fund who's found guilty of breaking Canada's ethics laws. This is, of course, the latest in a long list of Liberals to have been found to have contravened this act. In your investigation, did you find that former Liberal Innovation Minister Navdeep Bains was aware of Ms. Verscheren's conflict of interest with NR Store at the time that she was appointed? Just a quick yes or no, if you could.
We did not look at her appointment. That's not our job. Our job is to look at her, not the steps that go to her appointment, but once she is appointed, does she have a conflict and how can it be resolved? And by the way, what we did find, and let's make it quite clear, that she received incorrect legal advice, and that was the real problem. And her advice was, because it was an emergency COVID, conflict of interest issues do not apply. That was absolutely wrong. She followed that advice and voted on the subsidies that were given to all companies, to the injections in order to help them survive the COVID crisis. And what I found is, no, you shouldn't have done that. You should have recused yourself, should have walked out of the room because the vote affected a company in which you have an interest. She didn't do that, but she did on the record clearly shows that she was told no conflict of interest is here. And I spoke to her counsel, I cross-examined him and said, on what basis? And he said, on my knowledge of basic corporate law. There's no corporate law that I know of which says because there's an emergency, conflict of interest does not apply. So it was just incorrect advice that she followed.
Thank you very much. That is the time. Moving now to Ms. Bradford. Ms. Bradford, you have the floor for 5 minutes, please.
Thank you, Mr. Chair, and thank you for Commissioner for attending this meeting today. Again, the meeting was called and the subject was to be on ArriveCAN, but I see that MP Barrett has now shifted it to focus on sustainable development, Technology Canada. So along that line then, since he's chosen to steer this discussion in that direction, do you think that, so the Conservatives are continuing to cry wolf despite the fact that the government has taken responsibility for the lapses in the governance by implementing swift changes to address the situation? Since your report has come out, the STDC funding has now been transferred under the National Research Council, which should ensure more stringent oversight. Given your findings, how do you take the news of the structural changes and how will it lead to better accountability and oversight in your view?
Really, the whole issue of conflict of interest in an organization like STCC is key because you have to know something about the industry in order to know what kind of support they need and what kind of form that support should take. On the other hand, you can't have conflicts, etc., or you have to recuse yourself. So it is ever present. The STCC has a very elaborate code of dealing with conflict of interest, which mirrors the provision of the Conflict of Interest Act. All they had to do is follow their thing and to put it in. Unfortunately, because it was an emergency situation, they thought it didn't apply and they were advised that. I expect that now, under new, in light of my report, there will be heightened attention to their own internal code and our act, and an attempt to ensure that this doesn't happen again.
Thank you, Mr. Commissioner. So in looking at your interpretation of subsection 6.1, would it be fair to say that the mere existence of a conflict of interest wouldn't amount to violating the Act, but rather one's active participation and the making of a decision in instances where the individual knows there could be a conflict of interest? Is it my understanding that that's correct?
Yeah, if there's a conflict of interest, there are remedies. One of them is, I say, recuse yourself. Get out of the room, let the others make the decision, etc. Then you're perfectly fine. But if you stay on your vote or you participate in the discussion, then you get yourself into problems.
Right. And you found that Mrs.
really good at.
Verschuren did not sufficiently remove herself from decision-making in certain instances,
Right.
given she abstained rather than recusing herself. In so doing, she was deemed to have participated in decisions and contravened Section 6.1 and Section 221. If she properly recused herself in every single instance, would you have found her in breach of both sections?
No,
No,
because she
if
would have
had
recused herself.
There would have been no breach, contravention of the Act.
What a stupid
And
question.
in order to respect the Act and even STDC's own conflict of interest policies, individuals should have recused themselves. The AG found that there were 90 cases where the Foundation's conflict of interest policies were not followed, linked to $76 million of funding. Commissioner, given the lack of recusals, it is in these instances that STDC leadership would have contravened the Act, correct?
Not quite. I only asked to look at people who fall under my Act. Those are the people who are appointed by order and council. And there are lots of members on the board of STDC who are not appointed by order and council, and their conflict is not part of my remit. I find it shocking to see what the Auditor General has reported in terms of conflict of interest, etc. But it was not conflict of interest by reporting public office holders. And that's all I can look at as a group. Conflict of interest by reporting public office holders. And in this case, I was asked specifically to look at 2 reporting public office holders, and I looked at them, at their activities.
Yeah, stupid question. I
Can you
agree,
tell me
Lori.
how many current investigations your office has underway where they did meet the threshold of conflict of interest?
Right now?
Yes.
I have none. The last 2 were Mr. Verschuren and Mr. Vermette.
How do you not have...
At the present time, I'm not investigating anybody. There are no facts that have been pointed out to me or requests received from Minister at amount. Give me sufficient facts so that I have reasonable grounds to believe that the Act has been contravened, so that I can start an investigation.
Thank you very much. That is the time. Suivant, c'est Madame Sinclair Desgagne.
Up next is Ms. Sinclair Desgagne for her turn. Thank you, Mr. Chair. I will continue in the same line of questions regarding employees. I'll have a question about ethics. Of course, we're not talking about, maybe we're talking about conflicts of interest, but when it comes to employees, we agree that they're not nominated by the government, they're not appointed by the government, but there was a case where a CBSA employee appearing before committee admitted to having been invited by a company that did work for the government to whiskey tastings, etc. And this employee seemed not to be the subject of reprisals or internal investigations. On the contrary, they seem to have been promoted. Do you think that that's ethical? Well, as I said to your colleague, I am not in charge of these general ethics questions, but of course, someone who had similar behavior should not be promoted. But it's not up to me to make that decision. My opinion has no value. It's not my jurisdiction, and my organization isn't in charge of situations like that. I don't think that your opinion is worthless. You're the commissioner of of ethics and you're an official of the House of Commons. So, but you seem to be confirming that that case was clearly not ethical. And in my opinion, and many other people seem to think the same way, and maybe people who are tuning in, it is clear that there was a problem in the functioning at CBSA in the way that this employee was treated, despite having admitted to these behaviors that should not have taken place with contractors. So we seem to agree that that was quite problematic. I have another question about this type of conflict of interest. Again, when you look at the ArriveCAN situation, even going beyond conflicts of interest, it seems that there have been thousands of emails that were deleted.
Yep. Mendon.
Would you be able to draw the line between maybe not ethics, but compromising emails and what happened? Would that be illegal? Would you be able to enlighten us, or would that be outside of your jurisdiction again?
So this guy, oh, his mic's muted. Or something with the interpretation. Yeah, there's no interpretation.
That's
there we go.
Something that's quite troublesome, that emails seem to have been deleted.
So this guy has no investigations
underway.
underway.
What conditions and what rules
what does he do?
They were supposed to follow.
What does he do all day?
That might be in violation of the internal rules of the organization or criminal activity. I wouldn't be able to comment. But I find this, just like you do, to be quite extraordinary that something like this took place. And the AG is in the process of looking into this. There's an investigation going on. All the documents have been submitted, should have been submitted instead of being deleted. Thank you very much.
2.5 minutes, please.
Thank you very much, Mr. Chair. And I do want to just comment quickly on the situation at Sustainable Development Technology Canada that was brought up earlier. A question that I had during some of our original testimony hearing from SDTC was surrounding the condition of protection for the whistleblowers. In your office, I'm certain that over the course of time, I know you're relatively new, but over the course of time within the Office of the Ethics Commissioner and Conflict of Interest, there have been instances where whistleblowers have maybe come to other departments, including this department. How do you deal with ensuring the protection of whistleblowers in the conduct of your work?
Well, if people come to us and come forward with evidence that amounts to a conflict of interest, etc., we will, and we think there's reason to believe an investigation is required, we will do investigate. If it involves in a whistleblower, and that whistleblower says, I do not want to be mentioned, I want to remain anonymous because I'm afraid for my job, etc., then it causes us, obviously, an issue like everybody else. How do we deal with this? Can we protect him? But on the other hand, how can we assure ourselves that the fact that he or she divulges to us is something that is worthy of, is correct or not? So most of the time, you're asking me to speculate here, but I would think, we would probably deal with the situation that he has, or the facts that he or she has presented, and try to verify them without bringing him into the picture. Or if it's necessary that it's if it's not possible, etc., then you really have the unfortunate choice of the thing. If he or she doesn't want to testify, etc., do I have enough other areas, other facts, other evidence in order to proceed, or know that may be true, but since if he is not willing to testify, that's essentially then you have to close it down. These are very difficult issues to do when you're not dealing with a criminal behavior. We have no whistle protection or anything like this. I might very well tell that person, you think you should go to the Commissioner of Public Service Integrity and talk to her, because she has a specific mandate to protect people against retaliation in case there is whistleblowing. But to my knowledge, we have not had any situation like that. But if it arrives, it requires very delicate handling. That's all I can say at this point.
Thank you very much. That is your time, Mr. Daly. Now to Mr. Perkins, who's joining us online. You have the floor for 5 minutes, please.
Thank you, Mr. Chair, and thank you, Commissioner. I'd like to ask you about the Basharian report that you issued on the Liberal Green Slush Fund SDTC. You, in the report, acknowledged that you were aware of the parliamentary hearings as well as the Auditor General's work in this area. Is that correct?
Yes.
Then you were aware then that the Auditor General, as part of a report, identified 9 Order in Council appointments to the board who had voted conflict of interest, not just the one in Mr. Barrett's letter. And earlier you said that you only dealt with Order in Council appointments. Will you look at the other 8? Those 8 voted 186 times out of 400 times, 400 votes, 400 transactions, 186 conflicted, 44%, and those 9 directors. That's not bad legal advice. That's a culture of conflict of interest.
Would you please repeat your question exactly? I want to make sure that I misunderstand you.
The Auditor General identified 9 Order in Council directors, 186 times voted conflict of interest. Out of 400 transactions, that's 44%. Order in Council appointments, almost half of the money, $330 million. They voted companies they had a conflict of interest in. That's not bad legal advice, as you suggested in your report, is it? That's a culture on the board of conflict of interest, of self-dealing. Would you look at all 9 directors in those instances of conflict of interest?
Let's get the facts straight. I was asked to look at 2 Order in Council appointments, and I looked at them and their activities.
But we're asking you to look at the other ones.
Mr. Barrett's letter, you have the ability to investigate beyond being asked, I would assume. And in that, Ms. Basharian also voted herself, and you didn't cover this, or the board gave her companies $10 million, $10.4 million actually, from companies she had an interest in: Hydrostar, Cascadia, Seaweed Corp, Margrove Lithium, and Resonant money. Those are outside of the COVID payments. Did you look at those?
Are you suggesting that she did not recuse herself? Are you suggesting that she voted?
I'm suggesting she created a culture of conflict of interest with 9 directors all voting themselves half of the money from the Green Slush Fund, and you haven't looked at it. I want to know why you're not looking at probably the largest scandal in terms of dollars in conflict of interest, not only in this government, but in decades.
Yeah, what the hell does this guy do?
Michael, why don't you?
Yeah, I think I'll jump in here. The report makes clear that the Commissioner did examine every vote of every meeting in which Ms. Verschuren was the chair. So we didn't name specific companies that were the ultimate beneficiaries. The focus of the examination, in large part, was the involvement of accelerators in which Ms. Verschuren was associated. So the Verschuren Center and Mars Discovery District, who were nominating other companies for funding. So in that regard, we have a breakdown.
That's only one aspect. I'm sorry, but that's all. I have limited time. That's only one aspect, and I'm curious as to why you're not looking into the broader issue of a $400 million scandal. The Auditor General identified $330 million of conflicts. One director who sat on the board and time on the board had from Quebec named André-Lise Matteau has $97 million go to companies she has venture capital interests in. That's all been identified on the time. 9 directors in the Auditor General report, all Order and Council appointees. Why are you not investigating those conflicts?
You know, Order and Council appointees come in 2 varieties. You have reporting public office holders and you have public office holders. Public office holders are those who have to comply by the act, but they do not have to at the beginning of their appointment. They don't have to come to us, show what they owe, and then
that doesn't matter. You can still investigate them.
I hear you, but I'm trying to give you the context. We
don't need context.
You're putting me a question, and you're doing it on the basis of facts that you think there has been a lot of misbehavior and you're not investigating. I'm looking at the people who have reporting public officers. While we were doing the investigation of Madame Michoud and Mr. Whine, the Auditor General did her report. Her report came out long after we had finished investigating these.
So why aren't you investigating?
Mr. Perkins, I'm afraid that is the time. You, I'm sure, have another opportunity later in this meeting. Turn now to Ms. Khalid. Ms. Khalid, you have the floor for 5 minutes, please.
Thank you very much, Chair, and thank you, Commissioner, for being here today. Commissioner, I'll start by asking, have you heard of the Conservative opposition motion that was passed on June 10th, was presented on June 6th of 2024 in the House?
I'm sorry, I'm not aware what the motion you're referring to.
So this motion required a production of documents from the government, the Auditor General, SDTC, to be presented to the Law Clerk and Parliamentary Council with the intention of providing these documents to the RCMP. Now, in a recent letter that was to this committee, the RCMP Commissioner sounded the alarm, saying that this House order, which is this motion I'm referring to, is interfering in operational and police independence. This is happening in a free and fair society like Canada. Commissioner, have you ever seen instances where the legislative branch tried to interfere or direct police as to how to do their jobs?
No.
Yeah, the Freedom Convoy.
I'm not aware of any.
What is this chick talking about?
And how do you feel
conflicts of interest
about that interference?
Who cares? That's not his job.
You know, are you asking me to comment on the
something that's not his
job? The behavior
of
Parliament. I'm a servant of Parliament. I do what you direct me to do. It's a bit hard to suggest that asking me to say whether there's a motion passed by Parliament was appropriate or not. Obviously, the Commissioner of the RCMP feels it's not proper under the circumstances. And, you know, if he will have good reasons for explaining, and I presume you should ask him rather than me about this.
Yeah. Commissioner, respectfully, I do believe that even though you're an employee of Parliament, you have a very, very important responsibility to be hands-off, to be independent of the actions of Parliament. In fact, you oversee a very important aspect of what parliamentarians do. Now, the Auditor General was recently in the news saying that this specific Conservative House motion would compromise her independence. Commissioner, what's your reaction to hearing a fellow officer of Parliament sound the alarm that parliamentarians are putting her work and her office in jeopardy?
Well, obviously, it's of concern. I mean, the whole way why we set up these various offices are to be independent of any politics and to come up with the facts and present them to the public, and inform the public of what's going on, and if there's any misdeeds or anything that is shouldn't have done, to expose it, and anything that's done to interfere with the independence of this and put in question any report that's issued by one of these offices defeats the whole purpose. I mean, you are independent. That's why you are trustworthy. You're not influenced by outside influences. You're not. You have to be. What you have to do is find the facts and expose them, and that should be done as without any interference from Parliament.
Now, is it usual practice for an officer of Parliament to raise alarm bells like this in your experience?
I'm not
new
aware
to his
that
position.
From personally, I'm not aware of that it has been done before. It may have been. I haven't researched the issue.
It's a stupid question.
It is, as you said, Commissioner, quite alarming that that parliamentarians would interfere with the work of independent office holders that are there to provide scrutiny. So, it is quite troubling in my point of view. Now, the government has addressed the situation that we're talking about today, which is what I think Canadians expect of our government, but that doesn't quite suffice for the cons. Because what matters most for them is to create chaos. And, Mr. Poilievre and his cons, they thrive in chaos. They need to create it everywhere that they go.
What the
And in turn,
hell?
they look to hurt trust in our institutions, including your office, Commissioner. So when they use the House to direct or to seek influence police in this country and compromise officers of Parliament, they're looking to hurt the trust in the institutions that they one day will seek to govern. Commissioner, in your view, what is the long-term damage that is being done to Parliament and to institutions based on this conduct?
What does this have to do with conflict of interest in his job?
Judgment. I'm sorry, I cannot do that. You're basically suggesting that the action of your opponents are undermining the system and will cause damage in the long term, and I want me to agree. That's for people. That's for you to judge as the electorate, not for me.
I'm afraid that is the time all around. Beginning our third round, Mr. Brock, I believe you have the floor for 5 minutes.
Let's get the Brockinator in here. Get some real questions, baby.
Welcome, Commissioner, and welcome, Council. It's always good to see you back. I guess the first concern that I have is I'm quite astonished of the commentary from my colleague, Ms. Khalid, in terms of her interpretation of a demand for documents as saw fit by a majority of members of Parliament. And as you will agree with me, I'm sure, Mr. Commissioner, that Parliament is supreme. Committees are supreme, and we can just about order anything we want unfettered. Absolutely. In fact, the House of Commons top lawyer basically affirmed that position, that documentation needed to be produced to get to the bottom of yet another scandal by this corrupted Liberal government under Justin Trudeau. So perhaps Ms. Khalid needs to be informed that simply obtaining documents and forwarding those documents to the RCMP is not and never would be seen to be interference. It aids in their investigation. She is somehow suggesting, wrongly and deliberately wrongly, that by asking and furnishing documents to the RCMP, we are directing an outcome, which you know, Commissioner, is completely ridiculous. The RCMP are completely independent and are unfettered in their decision to lay charges or not. You'd agree with that?
Yeah.
Arrest Trudeau.
Regardless of what Parliament said, regardless of what Justin Trudeau may have said, they have that final discretion. So Ms. Khalid needs to be educated on the powers that the RCMP actually have. But a broader concern I have is this. Really, why are you here, Commissioner? As much as I enjoy listening to you and listening to your counsel, you were selected and you were chosen to come here by the Liberal Party. And right out of the gate, they asked you questions about your mandate as if they didn't even know why you were here. As we well know, and you can confirm, Commissioner, there's at least a dozen other investigations into this ArriveCAN scandal, including the Auditor General and the RCMP and numerous colleagues of your level, various commissioners, actually examining this scandal. Why weren't they here today? But they chose you. You made it clear to this committee earlier this year that you have no mandate with respect to the ArriveCAN, do you?
I don't. And my opening statement today made that absolutely clear.
Made it abundantly clear. So this is now twice you've made it clear you have no mandate. Yet the Liberals wasted this committee time and wasted your time, sir, from doing the good work that you are obviously doing throughout the year. How much time do I have?
Mr. Brock, just to hold, I want to just push you back in your lane. The witness is here, the invitation of the full committee. So I appreciate you're welcome to raise his relevance, but he is a committee witness. So just a nudge back in if you could on that. There are no
certainly.
Yeah, I appreciate you've got a minute 45 left.
Okay, so let's get to your report, the Verschuren report. We've heard from my colleague, Mr. Perkins, that she somehow benefited from the decision making that she either made or abstained on voting but not recusing herself, upwards to $10 million. You found her guilty of breaching two aspects of the Act. I want to know, and I'm sure Canadians watching this want to know, what is the penalty for her?
Yeah.
Penalty for her is, as the Act provides right now, basically exposure.
Sorry?
Exposure.
Exposure.
Yeah, you know, if you
Name
want, you had a conflict of interest. If we expose it, you get it certified. It does damage to your reputation.
No
That's
fine,
how the Act works.
no
The
jail
Act does
time,
not
and
have
she
any
stole $10 million.
Except for minor penalties on reporting things, and as the consequences are to obviously, if the person who appointed her, she has resigned, but if not, for instance, one option it would have been for the government to ask her to resign, etc. If they felt the breach that we pointed out was severe enough, etc. As my colleague pointed out, we went through every single vote of hers. So these allegations that are here that she supposedly voted on issues of up to $200 million to the benefit of her, etc. As I say, we looked at every vote that she did, and she recused herself when required. At least that's the evidence, Michael. If you want to elaborate on that.
What is his job? What does he do?
The whole focus was the emergency votes. That's what Mr. Barrett's letter asked me to look at, and we looked at. And in the process, we also looked at votes that she did with regard to incubators, and we found that she violated. She should have recused herself, not abstaining, because there's no provision for abstaining in the Act, except if you're a member of Parliament voting something on a minister. So here we find it is the whole process is essentially, if you want to put it bluntly, is we investigate, we expose, and to some extent we do damage to your reputation. That's all we can do. The person who appointed, we're talking about a reporting public office holder, whoever appointed them can decide if they want to do other actions.
Meanwhile, the taxpayer is owed $10 million.
Mr.
Yeah, we paid $10 million for her to just have a rest of her life.
Very much, Chair, and I thank you for correcting the record earlier when Mr. Brock was claiming that we had called the witness and we were wasting time and we were having these meetings that is wasting members' time. Thank you for correcting that record, because as a member of Parliament, as someone who takes this committee very seriously, to see it being used time and time again to push the conservative narrative, a false narrative, a narrative which is going down rabbit holes and witch hunts and God knows what else is going on, not allowing the duly appointed independent officers of Parliament to do the jobs that they have to do. Because if it was the case that those officers of Parliament, of which I'm very glad to see the Commissioner here for Conflict of Interest and Ethics, if they were not doing their job, then indeed parliamentarians would be called into action. But when they are doing their jobs, the RCMP, the Auditor General, anyone else that is doing their investigation, we must let them do their work. And I want to read out now, for the record, from the letter from the Commissioner of the RCMP. And this is the letter, Chair, that we were sent July 25th. It's a letter that is directed to the law clerk, Michelle Bedard. The RCMP has reviewed the implications of the motion. This is the motion of June 6, in a potential criminal investigation. Before taking any investigative steps to access documents that may give rise to a reasonable expectation of privacy, the RCMP must comply with the applicable legal standards to preserve the viability of any potential criminal investigation or prosecution. The Parliamentary Production Order does not set aside these legal requirements. The Parliamentary Production Order does not set aside these legal requirements, I repeat. For the reasons set out above, the RCMP's ability to receive and use information obtained through this production order and under the compulsory powers afforded by the Auditor General Act in the course of criminal investigation could give rise to concerns under the Canadian Charter of Rights and Freedoms. It is therefore highly unlikely that any information obtained by the RCMP under the motion where privacy interests exist could be used to support a criminal prosecution or further
it's called
a criminal
cabinet confidence that you're using to block the RCMP.
2 minutes, 20 seconds.
Excellent. I continue. Given the risks associated with receiving information under the motion or other compulsory authorities, practices need to be put in place to identify the nature and the source of the information, with a view to determining whether it contains charter-protected information. Charter-protected information.
Cabinet confidence.
Any information obtained through the motion or other compulsory authorities would need to be segregated from an RCMP investigation.
I can't.
There
I
is
gotta go grab a drink.
significant
I can't
risk
listen to her. She's gonna make me go mad.
that the motion could be interpreted as a circumvention of normal investigative processes and charter protections. I'm going to repeat that again, Chair. There is significant risk that the motion could be interpreted as a circumvention of normal investigative processes and charter protections. The RCMP will continue its review of available information, so on and so forth. I'd like to hear the Commissioner's views on what I just read out.
Look, if the Commissioner states the law, and so it points out that there could be possible challenges based on the Charter, which is a fact, you know, whether there will be or not, etc., without anything more. I think nobody can argue with him that Charter comes first, and we have and if you have information that you garnered in an investigation and that was furnished here, etc., you have to be very careful for how you use it and when and where and how. And I mean, I think he is, as far as I can, from the letter that you just read, seems to me, just pointing out there's normal legal concerns.
Indeed, the government has taken corrective steps in order to ensure better oversight and accountability to the personnel and finances of STCDC, because, yeah, stuff happens.
Yeah, stuff happens. $10 million.
And we need to have the processes. We need to have the processes in place in order to investigate and to make corrective action, which has been done in this case by transitioning this program to the National Research Council.
Thank you, Ms. Shanahan.
But we're not looking for solutions here, are we? We're just looking to muckrack.
We will certainly come back to this. I expect suivant, c'est Madame Sinclair-Desgagnés pour 2 minutes.
Up next is Ms. Sinclair-Desgagnés for 2.5 minutes, please. Thank you, Mr. Chair.
What the
All
hell
my
was that?
colleagues
Really, what the hell was that?
referred to Sustainable Development Canada. Just a second.
Order in this chamber, please. Madame Sinclair-Desgagnés, pouvez-vous...
Ms. Sinclair-Desgagnés, can you please take it from the top? 2.5 minutes. Okay, I will start from the beginning. I fully understand, of course, take some time. I will reset the clock when you're ready for 2.5 minutes. Okay, thank you, Mr. Chair. Now, when it comes to Sustainable Development Technology Canada, a lot of colleagues referred to the situation, and you published a report. So I have a question about that. There are some parts of the report where you say that Madam Verschuren possibly acted in the manner that she thought would take care of or resolve of her conflict of interest. So she abstained rather than recusing herself. Is that the case?
No.
Oui.
Yes. Did you hear my question? Yes, your summary is quite on point. Okay, thank you. Well, what I'm curious about in all that, Commissioner, is that these are these appointed people, individuals. Do they not follow a training on conflict of interest? Well, it really depends on the organization. If the organization has a legal counsel, they would normally explain to them what the rules and expectations are and what kinds of behaviors are expected of them to avoid conflicts of interest, etc. But if the organization chooses to have an information session on conflict of interest, well, in this very specific case, in this case of this individual, when they assumed their position, did they not receive training about the expected behavior and ways of avoiding conflicts of interest? Well, not from us. No, but in general, because that's quite important. Because if there's no training, then it's quite problematic because they are in charge of public funds. And if there was a training, well, if they followed the training like many other people do, how can we assume that they're acting out of goodwill? Because these are people occupying very important positions on different boards where financing is attributed. Well, how can we know that they did not maybe fully understand the or digest the information? If that is the case, we have a serious problem. Well, listen, clearly I do not know the details of what happened at SDTC and what the information was that was made available to members of the board. We have very limited information. I find it very hard to imagine that they did not have a training session with Madam Verschuren, because that's normal in every organization. It's a question of finding out what exactly happened with the different members of the board, because there were a certain number of cases where she was informed that there was a conflict of interest. She took that into account, but she did not recuse herself. So that is a technical violation, if you will, and the Act is clear on that. You need to recuse yourself. She declared the conflict of interest, but she voted still. Okay,
so
thank you very much.
Who cares if the punishment's exposure? Why not just keep doing it?
Thank you very much, Mr. Chair, and thank you
$10 million.
again, Commissioner, for being present to answer
Nobody
questions.
cares. There's no
to
fine.
SDTC. I know that you're unlikely given notice about these questions, and so I do appreciate your comments now on the topic. So, it was earlier identified, and my colleague, Ms. St. Clair de Gagné, did mention an aspect of the question I wish to pose, which is related to Ms. Verschuren denying claims of conflict, saying that she got legal counsel or legal advice, that she did not have to recuse herself because her firm was a group of 100 companies that received the same level of additional funding. You know, we obviously know now that that's not the case and shouldn't have happened. But can you respond to her claims and tell the committee why her case is still relevant under the Conflict of Interest Act?
It's relevant, I think, as a lesson to other companies, etc. follow the rules that are set out for you in the Act and in your own in the company's own code of conduct. If you follow them, there's no problem. If you have a situation like we had with COVID and saying because it's an emergency now and because all the companies get it, not only the one company in which you have interest, therefore in conflict of compliance, follow your own judgment. It's, look, you're going to benefit from it, so let's get out of here and let's not vote on it. So in that case, you're clean free. And that's really the message from all of this. No matter what, you have the rules, follow them, and you're clear free. Anybody telling you it doesn't apply in this case, look at it with a great deal of caution.
No, thank you very much for that, Commissioner. I think that's the most important lesson from this situation is that the conflict of interest, regardless of whether or not one attempts to avoid accountability, and that the recusal portion of that admission is most critical to ensuring that that person, in this case, Ms. Verschuren, could understand directly that conflict. Isn't that correct? That the process, the recusal process, doing that is the most important piece to understanding one's own conflict or perceived conflict. Correct?
Yeah, correct.
And I also know that there has been trainings, there are ways that this information gets to public servants or even to others. Is this something that you think your office could enhance its work in doing, is ensuring that officials like Ms. Verschuren and others in like positions in these boards of management understand these rules of recusal better?
You can always improve on what you do, obviously. What we do right now, like somebody like Verschuren, she gets appointed. The first thing, she gets a letter from us saying, welcome to your center. Please fill out this very extensive questionnaire so we can go then sit down with you and find out if you have a conflict and what has to be done. That happens. And there are some certain steps taken, most usually either establishing screens or insisting on blind trust, etc.
Okay, come on, get to Barrett or Brock right after this.
This is your advisor. She is there for you. And
after this.
If you have any problem, call her. She will tell you. Is that okay? And then,
or maybe he's got like another minute left.
If there is an issue, she calls and we will help her resolve the issue. So we do that. Secondly, if the organization asks, can you do a briefing session on conflict of interest for our board members? We'll gladly do that. We'll send somebody over to two people and walk through. So we're trying to do as much as possible. But the main thing is that you have to be aware of, and if you are in these positions, these are public trust positions, the rules applied and they will be enforced. And if you are in doubt whether there is, call us or don't vote. You know, if you think there's a possibility of conflict of interest, it usually is. You know, so
thank you, Commissioner. Thank you, Commissioner. That is your time. I'm going to just suspend for 5 minutes for a health break. We'll be right back.
Okay. So one thing I want to point out just before, while they're taking their break, just before we get back up again, is since they're having Aaron O'Gorman come back, and we watched that one clip there with the Brockinator. Actually, we can finish that up because we didn't finish this clip.
Absolutely dispute that. Your question was not, did you meet with the Privy Council office or the Prime Minister's office before your appearance to discuss your appearance? Had that been the question, I would have said no. I have never met with PMO with regards to any of my Mr. Chair, may I finish my? May I finish?
No, this is my time. This is my time.
I believe there was a statement that was erroneous that I'm fixing. If the question was, did I meet with the Prime Minister's office?
Order. I think, Ms. Yip, I think I'm going to. Why don't you, Ms. Yip, a point of order, which I think I'm going to preempt, but go ahead. I see your hand up. You're on mute.
Sorry about that. Yeah, my point of order is the witness should be allowed to answer, and also that 80 Wellington is the PCO, not PMO.
Thank you. So, I just want to bring a little order. So, Ms. O'Gorman, hold on. I'm going to turn it back to Mr. Brock. This is his time, and in this process with other questioning, if something you feel you haven't been able to answer, another member can certainly turn to you. But unfortunately, all members are on the clock, and they have discretion about how they would like to use that time. I know that can be frustrating, but I just want to clarify that. So, Mr. Brock, you have about a minute and a half. Over to you, please.
Thank you.
So, Ms. O'Gorman, you are going to table all the names of all officials at the PMO office and the PCO office that you spoke to before and immediately after your committee meetings on this ArriveCAN study. You are also going to give us details as to what you discussed, because I know there's an email from October of 2022 that the PCO was very interested in the ArriveCAN study. You were CC'd, and actually an email directed to you regarding that. So you wanted to provide information to the PCO on the ArriveCAN study. I find it extremely suspicious, and I'm sure Canadians do not believe you, ma'am, when you say that it was merely a coincidence. Before and after your meeting with the PCO, you did not discuss your testimony and you did not discuss the ArriveCAN. So we'll wait for your information to be received. Now, the RCMP is investigating thousands of emails deleted by Min Doan, a former employee of the CBSA. Have you been able to recover some of those emails, yes or no?
The team is investigating the allegation. I don't think it's been established that... Mr. Chair,
some of those emails? Yes or no?
I don't believe it's been established that the emails were deleted.
Have you recovered some of those emails that were not provided to the RCMP or the Auditor General? Have you since found and be able to recover some of those emails?
I have not understood from neither the Auditor General nor the RCMP that they were not provided with emails that they were seeking.
Ma'am, there is evidence.
No, sorry, Mr. I'll hear that point of order in a second. Mr. Brock, your time is up. I heard a point of order. Is that Ms. Khalid?
Okay, so obviously that's Aaron O'Gorman, right? And that's who we're calling back to the committee. And she's not going to be very truthful. Obviously, we know that. MP Brock very distinctly confirmed that she goes to AD Wellington before her committee and after her committee. So she's definitely being told by PMO officials, which is the Prime Minister's office, Katie Telford or whoever else in the PMO's office is directing her exactly what not to say in the committee. And Liberals are really good at answering a question with a question, filibustering, just doing anything they can to ruin the time. Like one good tactic they'll do is, thank you for the question. Every single time someone asks a question, thank you for the question. That just eats up the five. At the end of the 2 hours, if you're constantly thanking every single question, you've probably thanked for like 15 minutes. You've literally filibustered 15 minutes of the meeting. So that's probably what we're going to get if we get Aaron O'Gorman again. Which she's supposed to be attending in September after that motion just passed today. They probably have another 2 minutes here suspended. Shouldn't be much longer than that. There's one other clip I wanted to show while we're waiting. So this is what I'm talking about when I talk about...
With some respect, I don't believe you truly recognize how damning your evidence has been to the Justin Trudeau government. You talk about Mr. Nijjar exercising due diligence and researching GC strategies, but GC strategies, according to the Auditor General, receive upwards to $20 million for doing nothing other than connecting government officials with companies such as yourself. $20 million. They're a pariah. GC Strategies is persona non grata. They've lost all their contracts with the government. They've lost their security clearance. And you aligned yourself with GC Strategies, which brings into question the RCMP may be knocking on your door. So if you haven't lawyered up, you probably should be considering doing that. GC Strategies testified not under oath, but there is a presumption of telling the truth at committee, to committing criminal acts of fraud and forgery. And this is the company you aligned yourself with to the tune of almost $400,000. Is that correct? Mr. Nijar?
Thank you for your question.
See?
KPMG is not aware of anything related to GC Strategies outside of the work that
The
we
amount of the
performed.
contract, was it $400,000?
The amount that we charged GC Strategies for the cyber work was
$400,000. They receive 15 to 30% for doing nothing.
Point of order.
The government could have contacted you
Just 1 second.
directly.
Mr. Brock, I've stopped the clock. I have a point of order. I didn't recognize the name, so if you could just identify yourself again. Is it Mr. Biddle?
Hi, my name's Chris Biddle. We've been colleagues for
Hi, Mr. Biddle. I thought it was you. I wasn't 100% sure, so I heard you in the earpiece, but yes, you have a point of order.
I didn't raise the point of order when Mr.
Nobody
Brock
knows who
spoke
you
the
are,
first
dude.
time. He's cutting off as the witnesses are answering his direct questions. I know it's an issue of intense interest for all of us, but he's cutting off the witness at all of their answers, even as they're answering the question. It's not that they're being evasive, and I'm having a hard time hearing it, and I imagine the translators will be experiencing the same thing as well.
All right.
You just let them answer.
Thank you for raising that. Mr. Brock, if you just kind of keep that in mind for I'm finding the answers, I'm hearing them loud and clear, but I'm in the room. So Mr. Brock, if you can just kind of just be aware of that for people that are not in the room, which of course is their right as members to Zoom in virtually. So
Mr. Nijar, you indicated you didn't know about the
He's like, whatever, let me get back to my question.
unusual, if not illegal practices by...
Okay, committee's back on.
5 minutes, please.
Chair, I just want to take a minute to just quickly respond to
So that's what I mean
Ms.
about
Shanahan's
thank you for the
very
question.
animated opinions on what Parliament can and can't do. So a majority of members of the House of Commons passed a motion. And so that's important. A majority members of the House. So the Liberals want to act like they have a majority, but certainly they don't. And a majority of members saw the corruption of this Liberal government and passed this motion. And the motion calls for documents to be sent to the RCMP. And Ms. Shanahan read a letter, and I just want to share from the Parliamentary Legal Counsel a quote from his letter to the Speaker of the House of Commons. The power to send for documents is absolute and unfettered, period. It is a constitutional parliamentary privilege not limited by statute. As such, the House is not constrained by statutory obligations contained in legislation such as the Access to Information Act, the Privacy Act. I also note that the order did not contemplate that redactions be made to the document or that information be withheld. It's without limit. It's absolute. So they may not like it, and they certainly don't seem to understand it, but it's the law. And a majority of members of the House who were democratically elected made that decision. Now, we know that their Prime Minister, Justin Trudeau, favors a dictatorship, but that's not how our system works. Now, the Commissioner of the Royal Canadian Mounted Police does report to a minister in Justin Trudeau's cabinet, as per Section 5 of the RCMP Act. But the RCMP, of course, has full and final discretion on the investigations that they launch. But that's not going to stop Parliament from doing its job. We'll make the information available. The RCMP can choose to investigate or not. But much to Mr. Trudeau and his Liberal members here's chagrin, this is democracy, not a dictatorship. A majority of members of the House made a decision, and they can call independent officers of Parliament here to get them to opine on it, but it doesn't change the fact that it's legal. It's the right thing to do, especially after 9 years of the most corrupt government in history, and that's what we have with these members in that Liberal government. Commissioner, I want to move on to yet another Liberal scandal. Did you have an opportunity to review the testimony of Mr. Stephen Anderson, who's the business partner of Justin Trudeau's minister from Edmonton, Randy Boissonneau? He recently appeared at the Ethics Committee. Did you have an opportunity to review that testimony,
I
sir?
said this at the beginning.
Opportunity. I read about it in the paper. I did not watch it personally.
So there's new evidence that was presented of a business-related text messages between Mr. Anderson and a client of Mr. Boissonneau's company. Now, in these messages, Mr. Anderson refers to Mr. Boissonneau 9 times, saying there's going to be a partner call. He went on to admit that there was only one Randy at the company. And we even saw in these text messages that Randy was in Vancouver, Randy in the text messages, the same time that Justin Trudeau's minister, Randy Boissonnault, was in Vancouver at the cabinet retreat. So the evidence of Randy Boissonnault being involved is quite heavy. It's contained in the text messages that were presented at the Ethics Committee. Does this new information require a further look into the matter by you? A brief answer, if you could, sir.
Well, I'm sorry, I can't give you a brief answer, but I'll give you an answer. Okay. As you raised this issue, no, you raised this issue with me before. I looked into it and saw whether there was a reasonable grounds to start. I became convinced that on September 8th, which was the issue day in question, I'm waiting for you because I'm talking to you. I want to see, we have to make sure we both understand each other. It concerned September 8th. September 8th, there was no way Mr. Boissonnault offered to give me all the information on September 8th. His conversation, telephone conversations, emails, whatever. And we looked at all of that, and there was absolutely no way that there was contact between him and Mr. Anderson. Now this new stuff has come up, which I wasn't unaware of, and I wrote to Mr. Boissonnault again yesterday, and I said, I am concerned about these things now. Please, and these are September 6th and 7th. So far, I know there was no communication on September 8th because you were in cabinet locker and I have all the documents. Mr. Anderson's email suggests that he was in contact with you. Would you please provide me the same information for September 6th and 7th as you've done for 8th? When I get that, I will determine whether Mr. Anderson is using the name in vain or whether there was actually conversations.
Brief time left. I appreciate the answer that you're looking for more information from Mr. Boissonnault. Yeah. How can you be assured that you're receiving information from all of his text messages? We know that he used the app called Signal. We know he used other text messaging apps. Are you certain that you have the messages from all of the messaging applications that he used, including Signal and any other instant messaging application?
We specified in the letter that we want any means of communication electronically, it is between the two of them, whether it's, as you say, Signal or Skype or whatever you use, etc., or telephone contact. Once I get that information, I will be able to exercise my judgment, say, as a reasonable grounds to suspect that there was an involvement of Mr. Boissonnault in this, and therefore an investigation is launched, or really, no, his name is being used in vain by Mr. Anderson in order to give extra credibility to his emails.
Okay, I appreciate your answer.
That is the time. Ms. Shanahan, you have the floor again for 5 minutes.
Oh, no, please.
Thank you, Chair. And wow, this is very interesting. If the Conservatives were not so obsessed by pursuing their own convoluted conspiracy theories, narratives, attacking members of Parliament, especially members on this committee at every turn, we see that the partisan objective of the members who are making these accusations. And it is when, we're all big boys and girls and, we can all play in that arena. But when it involves independent officers of Parliament, and we just heard the Commissioner saying that he is disturbed when he hears of fellow independent officers raising the alarm that their work is being interfered with or could be compromised, then I think we need to take heed. We need to take heed. And indeed, I want to finish with the letter that I was reading earlier from the RCMP Commissioner. The RCMP will continue its review of available information that does not give rise to concerns under the Charter to determine if sufficient evidence exists to launch a criminal investigation. I would like to emphasize as well that the RCMP is operationally independent and strictly adheres to the principle of police independence. In a free and democratic society, this ensures that the government cannot direct or influence the actions of law enforcement and that law enforcement decisions remain based on the information and the evidence available to police. Am I to infer by the comments of the members of the Conservative Party that they would interfere with police investigations? Because that is what I am hearing. Puis je veux continuer en français parce que...
And I will continue in French because I know that the people in my riding are very concerned about what is going on. So when you look at the letter from the RCMP sent to Michel Bedard, who is a legal officer, so it says the RCMP also looked into allegations of potential criminal misconduct in order to launch an investigation and have access to documents within a reasonable time frame. And the RCMP has to abide by the applicable legal norms when it comes to the feasibility of all investigations. And the parliamentary request for the production of documents does not change that obligation. Therefore, the RCMP has the capacity of receiving and utilizing information and documents obtained in this manner as part of criminal investigations to respond to concerns in compliance in line with the Charter. So the information collected by the RCMP is collected in line with regard to privacy considerations as well. And I will continue with the paragraph in the last line. There's a significant risk that the motion be interpreted as a derailment of the regular procedure. The RCMP will need to determine if there's sufficient evidence to launch criminal investigation. And I would like to underline also that the RCMP is independent from an operational point of view and adheres strictly to the principles of independence of the police force. In a free and democratic society, this principle has to be guaranteed so that the government cannot intervene in these processes and that the processes should remain founded on the evidence. So that, Chair, is very important to take into account, and for us as parliamentarians, unfortunately, we have seen this elsewhere before. The quest for scandals by the opposition is so partisan that it risks really undermining all the good practices when it comes to these types of investigations that we have had here at the Parliament and at all the other institutions. Thank you very much. Thank you very much.
Fourth and final round. Mr. Brock, you have the floor. I understand you might be sharing your time. Would you like me to let you know when you're halfway, or are you going to hand it off?
Halfway.
Very good.
I'll start by saying I'm on behalf of the Conservative Party, I'm just so sorry that we have offended Ms. Shanahan in our job in terms of holding this government to account and discovering and exposing corruption at the highest level. So if that's offensive to her, well then so be it. That's our job. Commissioner, the issue regarding Randy Boissonneau, I appreciate you've only reviewed the actual newspaper story of the report. You didn't actually listen to the committee. You didn't read the transcript. Is that correct? Okay.
That's correct.
Are you prepared to do that given some of the concerns that have now been raised?
As I mentioned to you, I mean, the report...
Just yes or no, sir.
Look, I'm concerned because he admitted he lied.
Right.
He also, there are these emails that have emerged that use Randy 7 times, etc.
He was also supposed to provide us, sir. He was also supposed to provide the committee with additional emails, additional documentation, and actually the identity of the person that he claimed was auto-corrected 9 times. And he failed to comply with that order of committee. Does that concern you?
Yeah, of course. We hope it concerns you too, because we are talking about parliamentary process here, not my investigation.
And it would be naive for all of us to only conclude that what you received from Minister Randy Boissonneau were all the devices that he had access to. He could have accessed a burner phone that he never supplied to you. He could have used another communication app that he never supplied to you. You agree with me, sir, that there are still ways of communication that he did not supply to you. That is possible, is it not?
You are assuming here basically quasi-criminal behavior. I'm going on this. I would just first of all want the evidence. Once I have the evidence,
Do you believe there are burner phones out there?
Of course there are burner phones.
And do you believe there are other communication apps other than Signal and WhatsApp?
I just answered the question to your colleague. I said for any kind of information, let me have the response from Mr. Boissonnault, and then I will decide whether they are credible and sufficient, or whether I need any more evidence. And then,
Thank you. Hypothetical. Assuming you conclude that Minister Randy Boissonnault has breached the act, what are the consequences to him? Very briefly.
If first of all, I would have to begin an investigation. If the investigation comes to that, I make a public report and I send it to the Prime Minister. It's up to the Prime Minister to decide what to do.
You're at half, Mr. Brock.
Thank you.
Mr. Genuis, you have 2 minutes and 15 seconds.
Thank you, Chair. To the Ethics Commissioner, you just confirmed that you are further investigating Randy Boissonnault in relation to the infamous Other Randy affair. A partner at Randy Boissonnault's company sent many text messages claiming to be in communication with Randy Boissonnault and receiving direction from Randy about the work of the company. If he was given that direction, then that would clearly be a violation of the law. By his own admission, the partner lied by claiming that there was another Randy at the company. He also absurdly claimed that in every case Randy was mentioned, this was autocorrect. So you told us that your previous investigation looked at September 8th. Now you're looking at other dates, and I certainly welcome the further investigation you're doing in this regard. I just want to clarify something from Mr. Brock's testimony. It sounds like in seeking information from Mr. Boissonnault, in seeking text messages across all apps, all possible phones, that you're essentially using the honor system, that you're expecting honorable members to be honorable in handing over all of the information you've requested and not hiding anything. Is that correct? Is that the way you operate?
Yeah, well, can I just correct your terminology? We're not investigating. We were looking first time, is there enough credible evidence or reasonable evidence to allow us to commence an investigation? We came to the conclusion now, no, there wasn't. Now that the further emails have come out, we have asked for further proof that was there or was there not communication between Randy Boissonnault and Mr. Anderson. Once that comes out, I will have to look at, see where the information, and on that basis, make a decision. Look, they are reasonable grounds or not. I can't can't answer your question now because I haven't got that evidence in front of me.
Okay, but I just want to clarify one piece. In your request for this information, you're using the honor system. You're asking Mr. Boissonnault for the information, and you're assuming that he's going to give you the information, and you're only using the information that he gives you. It's the honor system. Is that correct?
I wouldn't call it the honor system. I'm asking the person directly implicated to give me all the information that he has on that basis. So if I do launch an investigation, I can put him under oath, I can put Mr. Anderson under oath, etc., and they would commit a criminal offense if they committed perjury.
Thank you. That is the time. You'll be able to come back to these if there's further questions. Ms. Yip, you have the floor for 5 minutes, please.
Thank you, Chair. I would like to return to the issue at hand. We are not questioning the powers of the House. The question is not about what parliamentarians can or cannot do. It is about what they should or shouldn't do. So I would like to go back to the letter and go back to the concerns shared by the RCMP. The RCMP warns of the risks and implications of documents produced by the House motion in a potential criminal investigation. They warn that these materials will need to be set aside from an investigation and that there is significant risk that the House motion could be interpreted as circumvention of normal investigative processes and charter protections. This should bring pause to all of us here. The RCMP and the Auditor General are warning parliamentarians, and I'm looking at the Conservatives here, of the risks and implications of a House order like this one. By clearly implying that there is criminality, the legislative branch, led by conservative maneuvers, is looking to direct or influence the RCMP to investigate and lay charges, infringing on operational and police independence. That is concerning in a democratic society. Don't get me wrong, our fact-finding work as parliamentarians is important, but when our work starts to hinder law enforcement, institutions, and parliamentary officers with the risk of jeopardizing the very values and trust in underpinning these institutions, then we have a big problem on our hands. Besides the RCMP, the Auditor General has also raised concerns. Commissioner, how many times have you sounded the alarm on parliamentary maneuvers compromising your independence? Is this a normal occurrence since you took on the role?
No, I've never had any reason to make that kind of statement or sound the alarm.
In your view, what are the ramifications of a compromised independence for an officer of parliament?
Look, I think you have to look at the thing holistically. There's three different principles here at play. One now is the supremacy of parliament. Nobody questions that. Another one is the independence of the RCMP to just at their discretion decide whether there's evidence for criminal prosecution or not. And thirdly, there's a Charter of Right, which is overriding and protects Canadians. And you have to make sure that those three, and you administer, they don't interfere with each other and they work together harmoniously. And what the letter of the RCMP says, you know, when you ask for Parliament, uses its rights, which it has to ask information, furnishes to us, etc. We have to be very careful how we use it, so that it doesn't either violate the Charter or impinges on our independence. And I mean, and that's the problem that exists, and that's a perfectly valid reason to state that that's an issue. How they will resolve it, I have no idea. I'm not involved in that. It's not my. But it would be the same if it involved my office in our investigation. We would have had the same problem of trying to reconcile these three principles which govern our system.
How would you use your office as an educational tool to educate the public in situations like this?
In a situation like what?
With respect to the concerns that were just raised.
You know, I'm not so sure that it's the function of my office to do that. If we had a situation where we are investigating and Parliament is ordering somebody to furnish it, etc., I would do the same. It would be in my final decision, be very carefully walking through the various steps and saying, here was this information, there's that information, there are these Charter of Rights concerns, etc., and the way to come to a final and fair situation respecting all three principles would be ABC. That's all I can. That would be my approach. Without having facts and in a situation, I really can't elucidate any more than that.
Do you think it's responsible of a member to predetermine the outcome of an investigation and to publicly share this view?
It's freedom of speech. They can do what they want. I guess the
you
electors
see the guy in the back laughing. Like, what a stupid question.
Have to decide whether that was appropriate behavior or not.
Thank you, Ms. Yip. That is the time. Unless you have a short question. No.
Fine.
Okay. Thank you very much. Appreciate it. Encore une fois, Madame Sinclair.
Once again, we're going to Ms. Sinclair de Gagné for 2.5 minutes, please. Thank you, Chair. I will mention something because in the last round, I was interrupted as I was starting by the two parties, the Liberals and the Conservatives, slinging mud at each other. So the Conservatives are now accusing the Liberals of being anti-democratic, whereas when it's question period, they are the party with the leader who has certain stances. And on the other hand, we have seen the Liberal Party that's demonstrated that they're incompetent and not able to govern. So the Liberal Party and the Conservatives slinging mud at each other, I think it's quite unfortunate because Quebecers and Canadians deserve better. And I just wanted to mention it here because we are supposed to be a committee that rises up to the challenge and that is supposedly not partisan, but at this point in time, we have these two parties going at each other in a manner that is not appropriate. So my last question to you, Commissioner, will be the following. If Ms. Verschuren, who had been nominated, who had been appointed as the president of the board, and if they followed a conflict of interest training, why would we question her goodwill? And I'm reading your report, and I quote, "It's clear that Ms. Verschuren thought to have taken the right measures to avoid the conflict of interest. However, she did not fulfill the requirement of the Act, and she should know about the Act. And if she is the chair of the SDTC, she has to know about the Act. And even without abstaining, she could have influenced the outcome of a vote. So it's quite absurd for me. Why are we showing such good faith towards her situation?" Well, your question centers around the requirements in the Act about abstention or recusing oneself. Well, if you recuse yourself, you're not there, you cannot influence the discussion, you do not have any impact on the outcome. And the other people in that same situation are free from any kind of pressure, or they have nothing to worry about saying something that could potentially offend the person that has now recused themselves from the situation. So that's why we say recuse yourself and let the board make the decision they see fit. Because if you abstain and if there's conflict of interest, well, you're still there, and even your presence can influence the outcome of these decisions or inhibit discussion. That is why what the Act requires is that you recuse yourself. That is why I do not understand why she did not do that at this SDTC meeting, and SDTC seemed to have accepted abstention, but the requirement, of course, would have been that she would recuse herself. But she did vote in other instances, so that shouldn't have taken place. You cannot say, well, there's a conflict and I will abstain, and then she remains and then continues to vote on other questions that implicates companies connected to her. So, as I said, that is a technical violation or contravention. Maybe that is because of ignorance, or maybe they were not paying attention. I don't know, but the Act is very clear. You need to leave the room. Thank you very much. Up next.
Your last round for 2.5 minutes, please.
NDP, yep.
Thank you very much, Mr. Chair. And I want to thank the witnesses again for being present. I want to thank my colleagues for your good questions. And I just want to reiterate the comment made by my colleague, Natalie Sinclair de Gagné, just calling for some order and decency in our work. It's troubled me, Chair, in the last while that it seems as though truth and decency are taking a back seat oftentimes to partisanship. And I think it's important as we prepare to come back to session that we try our best to unite on what is true It's clear that there are problems in the government. It's clear that there are issues with procurement. It's clear that there should never have been or should not be conflicts of interest that misalign or damage our institutions. And so just wanted to make that point very clear that I do certainly agree, and I call my colleagues to attention on what I perceive to be an issue that is placating our work here in a negative way. And I hope that we can continue to cooperate in finding truth and recommending real solutions to ending the kind of systemic issues that are present. Now, I do want to turn, Commissioner, to,
need to fire Trudeau and the Liberals.
The report of the OAG, the Office of the Auditor General, in relation to the SDTC. One of the issues that we investigated when we received this report was the issue of roles, that there was no clear definition of roles or terms of reference that would define roles, particularly when it came to an issue of the Assistant Deputy Minister attending meetings of the board. You may be familiar with this. It's found in section 6.74. I'll quote that. It says, the Assistant Deputy Minister of the department regularly attended meetings of the Foundation's board and received all board materials, but neither the department nor the Foundations documented what they expected from this role. We found that the director's understanding of the Assistant Deputy Minister's role was or did not align with the board's own, his own. This ambiguity led the board to believe that the Assistant Deputy Minister's presence at meetings provided an implicit agreement by the department for any decisions that the board made. It's deeply disturbing. Can you comment on just how that could affect the perception or even the very real conflict of interest that could be present when there isn't a clear definition of those board members' responsibilities, particularly when it came to even having a department member present, especially when the department member who was present had a different or conflicting understanding of their role there. The board perceived it as consent when, in fact, the ADM did not.
Thank you, Mr. Deja. Your time is up, so I will allow the Commissioner to respond, and I would just ask that you not interrupt because it will end it. So, Mr.
Of course,
Commissioner,
thank
you have the floor for a response, and then I'll turn to our next member.
The Assistant Deputy Minister is not a reporting public office holder, so any conflict he has doesn't fall under my regime, first of all. Why he was invited there and what, I don't know. That was up to the SCDC soon, and if they saw his presence being there as consent, etc., that is troublesome because they are supposed to make the decision on the basis of their best judgment, not because of it suits the department. But as I say, that's an observation from the Auditor General. It really has nothing to do with us in conflict of interest. A good government requires that in a meeting of the board of directors, you have the people, they make their decisions based on their best understanding and judgment. You have resource persons there. You do not have persons there whose influence, whose position or something could be seen as tacit approval or disapproval.
Thank you. Mr. Perkins, you have the floor for 5 minutes, the last conservative round, or the last conservative spot.
Thank you, Mr. Chair, and thank you, Commissioner.
Go back to your last line of questioning. I liked it.
Briefly on Mr. Genuis's last question. So in the mysterious Randy emails and documents and the Crest access you had, just so I'm clear, it's on the honor system, I think you said, so that he is not compelled legally under oath or anything to provide you with all the documents. It's just an honor system. Is that correct?
Forward. When the things first erupted, he wrote to me and said, I'll do anything I can to clear my name. What do you need? And I said, I need the following regarding September 8. And I basically, any kind of communications that you had on that day with Anderson, there was he gave me that. And now that September 6th and 7th are in, I say, well, this is totally new information. Would you please provide me everything that kind of communications you had on those 2 days with Mr. Anderson? The issues obviously being whether you had good dealings with him or whether your name was used in vain in order to enhance the position of Mr. Anderson.
So he was supposed to provide everything, he didn't, then you went back to him. So you have no way of knowing whether or not you actually have every document.
My capacity to investigate him is based on my being able to have reasonable grounds to believe. I had a mere fact that his name was mentioned in an email on September 8th, nothing else. Even Randy didn't even say Boissonneau. It's not enough to launch an investigation to constitute reasonable grounds to believe that something is wrong. Now we have 2 more days, in which suddenly 7 times the name Randy is used. I want to know, first of all, from him, what were your communications, if any, on those 2 days? Once I have that, I will have to decide whether I have reasonable grounds to believe that an investigation is warranted.
Even though he was a 50% owner in the ultimate company that had very few employees. But
he's entitled to be an owner of a company. That's as long as he's a silent
very few employees. There weren't many Randys there, unless you believe one of the Liberal MPs who may have said it was Randy. But I'll move on to SDTC. Part of your investigation was the Mars Accelerator Fund, which Ms. Visharian chairs Mars. Did you go further into that? Since Mars received, in the Auditor General's period, she audited 2017 to 2023, did you investigate the fact that Mars received almost $42 million from ISED? About a third of their funding comes from the federal government. Did you investigate at all the conflicts that she is in with regard to funding from Mars to her companies, NRStore and others, as part of that? Since federal government money is involved.
How does it constitute a conflict of interest that Mars receives funding from the government on a different
because
program?
she works for the government.
She chairs an organization that receives federal funding. She then has that organization vote money for companies she has ownership interest in. So you didn't look at that. The answer is yes or no, and you didn't look at that yet.
Michael?
Again, I just wanted to make sure, is the allegation that Mars directly receives funding from SDTC, or is that they facilitated the funding of other companies through their role as an accelerator?
Look, I thought it was pretty clear they received money. She chairs it. That fund, which has federal government money, has given money to companies she owns. But since you haven't looked at it, I'll move on. I think what's needed is a little more investigation, in my mind, by the ethics commissioner into this whole scenario. Every time we do an investigation, there is more uncovered. So I'm going to move the following motion, which has been given to the chair for the clerk, if the clerk can circulate it. Given the Auditor General's audit of Sustainable Development and Technology Canada, and given that the government appointed board members approved $330 million towards 186 projects, that's 44%, in which 9 Order in Council board members had conflicts of interest in violation of the Canada Foundation for Sustainable Development Technology Act, and B, $58 million towards projects that were outside of SDTC's spending restrictions outlined in its contribution agreements with ISEC. But the committee, therefore, expresses extreme concern with the blatant disregard of taxpayer funds, calls on the Minister of Innovation, Science and Industry to recoup these funds for Canadian taxpayers within 60 days following the adoption of this motion, and request that the Ethics Commissioner investigate all 186 conflict of interest votes and the culture of conflict of interest at the SDTC
I like this motion.
board.
I like this motion.
I put that forward, Mr. Chair. I believe you have.
Thank you, Mr.
available.
Perkins. Yeah, we're just going to make sure what you read is similar, and it has been sent. I'll turn the floor back to you in a moment, Mr. Perkins, and then I'll look for other speakers. I am going to excuse our witnesses because I believe this is not going to be a quick discussion. So, Commissioner, thank you very much for appearing today. Of course, you are welcome to sit and watch the debate unfold, since it does touch on your office, but you can also check the notes afterwards.
Point of order, Mr. Chair.
And
Ms.
Mr.
Khalid,
thank you as well. So you are
Chair?
excused, and yes, Ms. Khalid, you have the floor for a point of order.
Thanks, Chair. I was just wondering, I mean, I don't think that we need to excuse the witnesses until at least you rule that the motion is in order. I know that we have one more round.
What do you know about parliamentary
for
procedure?
the Liberals, at least, to be able to ask
What do you know
further
about
questions
rules?
of our witnesses.
I view the motion as in order, a matter of hand motion, and I'm going to turn the floor. Pardon me. I will retain the chair. Back to Mr. Perkins.
Thank you,
Ms. Khalid
Mr.
wants
Chair.
the
As
witnesses to
members
stay for
know,
what reason? Why
this
do they
came
need to see a
light
vote?
A little over a year ago as a result of whistleblowers providing hundreds and hundreds of pages of documentation to the Department of Industry. They then had a couple of months of private discussions with the CFO of the Department of Industry, who called the
Chair, point of order.
Allegations.
Just one second,
Yeah.
Mr. Perkins. I have a point of order from Ms.
Before the
Shanahan.
witness leaves, I'd like to challenge that. I do challenge your decision.
Why?
So you're challenging that the
Decision,
that the
decision
witnesses
that
can
this
leave?
is in order.
Challenging the decision that, that the motion's in order and that the witness be allowed to leave because we still have one more Liberal speaking spot.
All right, let's.
Chair, point of order. You cannot retrospectively challenge a decision that has already been implemented. If the chair makes a decision, you can challenge the chair in the moment where the decision is being made. I can't decide I don't like a decision you made an hour ago in this meeting and try to undo the proceedings that have happened since. It was ruled in order. There was no challenge. Mr. Perkins began his comments, and then Ms. Shanahan, maybe she got a note from a staffer, or maybe she.
Point of order on that same point.
Hold on. I'm hearing Mr. Genesis.
Stop smiling. Stop smiling.
I have a point on that same point.
Okay.
Chair,
I'm taking a
my
list
hand
of
was
points of
raised.
order, just one at a time. Mr. Genuis, you can wrap up, and then I will hear other points of order.
I'm done, Chair.
Okay, thank you. Ms. Khalid, you have the floor, and then I will hear Mr. Desjardins on a
really
point
don't
of
want to
order.
listen to Khalid.
And I see, Mr. Desjardins, your hand is up to speak to the motion as well. I will, but Ms. Khalid, you have the floor.
Thank you, Chair. And to counter what Mr. Genuis has said, this decision was made, the ruling was made, and within like a couple of seconds, you dismissed the witnesses and you gave the floor back to Mr. Perkins. This was not an hour beyond what the ruling was. This is right there instantaneously, and I agree with Ms. Shanahan on challenging your ruling.
Thank you. Mr. Desjardins, you had a point of order. Just one second, Mr. Brock. Mr. Desjardins is next.
Thank you very much, Mr. Chair. I do believe this is something we can overcome together as a committee. It's a very easy procedural issue that's obviously taken place here, Chair, and I respectfully ask that we get unanimous consent from everyone here just to allow the 5 minutes of questioning that the members are entitled to, just a matter of equivalency. I know if I was the member who was cut off from my questioning of a witness, just like if I was a Conservative member or a Bloc member, a Liberal member, that wouldn't be procedurally fair to disallow time for questions.
Bloc,
so I think it's very
NDP,
reasonable to suggest if we can just allow the 5 minutes
time.
with the Ethics Commissioner, they can ask their questions, and then we can return to the debate on this motion. I don't perceive that. I hope that's fair, and members can understand that this isn't. It's not my attempt to try to delay this any longer, but just if we can get unanimous consent to just do that. And Chair, maybe you can seek unanimous consent, and maybe members could we can calm down a little bit, allow the 5 minutes, and just continue our meeting and get to the debate of the motion. I think that's the most reasonable and most fair thing to do without descending into chaos.
Thank you, Mr. Desjardins. I have one more point of order from Mr. Brock. I see hands going up. If those are points of order, just say so, because I'm differentiating between a speaking list. But just hold on. So, all right, Mr. Brock, you had a point of order?
I'm withdrawing, Chair. Thank you.
Ms. Shanahan, you had a point of order.
So I appreciate Mr. Desjardins' comments. I believe the commissioner has gone, but
he
want
left.
to point
He's not
out
even
that
in the
I was
room.
also challenging the decision that the motion was in order
What's
because
the point in
indeed it's not
challenging
the
the
topic
decision
of
if you
the
can't get a
meeting. It's not on notice, and it's been, yeah.
Okay, so first of all, I'm just going to address Mr. Desjardins' point because I think it's the most relevant and speaks to the good work of this committee. Unfortunately, it's very difficult for me to do that because as motions come up, they have to be dealt with. Technically, you're right. I could seek a UC on that, but that also opens up the possibility of other maneuvers coming up as well. So That is not how we've operated in the past. We deal with motions as they come up. Now, Ms. Shanahan is challenging the chair. That is non-debatable. I'm going to ask the clerk for a roll call on that to either sustain my ruling, which is a vote in the yes, or to deny it, which is
I don't know why we're voting on this. The witness has left. We're voting to try and get more questions from the witness. He's already gone.
We return the floor back over to Mr. Perkins to continue the debate on the motion he has
This is a waste of time to vote on this.
Clerk, over to you, please.
The question is, shall the ruling of the chair be sustained? Ms. Bradford?
No.
Ms. Khalid?
No.
Ms. Shanahan?
No.
Mr. Ali?
No.
Ms. Yip?
No.
Mr. Brock? Yes. Mr. Perkins?
Yes.
That was a faint yes, but can you repeat that, Mr. Perkins, please?
Oh, there it is.
Yes.
Mr. Jennis?
Yes.
Madame Sinclair-Desgagnés?
Come on, Block.
No.
Oh, come on, Block. We needed you.
Mr. Desjardins?
Mr. Chair, I actually have or Clerk, I have a point of clarification. Is the challenge to the motion, whether the motion is in order?
Yes.
Or whether or not, whether the motion is
correct.
Not whether or not we're agreeing to the motion.
Correct. It's just whether the motion is in order to debate it now.
I see. Well, yes, I think it's in order.
Yeas 4, nays 6.
It is defeated, and I have excused the witness. This meeting is adjourned.
Okay, so that was that. That was a very strange vote at the end. I don't know why we couldn't get to a vote on the actual motion, because MP Perkins had a very good motion. He wants the ethics commissioner to investigate the rest of the $320 million that the Auditor General has said is misappropriated and missing. He's only investigated 10 million of it, and he already found in his investigation that there was conflicts of interest. So let's investigate the other 320 million. Why are we stopping? But anyway, guys, since the committee's done, you know what it is. We're done with the live stream for today. I'm going to get some more clips out. I didn't get any clips out on the channel yesterday, but I've got a couple good ones today if I can get them out. I've just got a few other things I got to do, but I'm investigating corrupt Liberals and their business dealings. So I've already got one on Stephen Guilbeault and his ex-business and how that is still getting government grants. I'd like to do one on Dominic LeBlanc. I'd like to do one on Anita Anand. I'm going to try and do a video for each. And yeah, there's no live tomorrow. Might be live next week, but yeah, that's it for today, guys. Everyone have a great day.